The Honorable Caroline Kendagor is the Mediation Deputy Registrar in the Judiciary. She joins us now in the studio to have a conversation here. Good morning, Honorable Kendagor.
Good morning, and thank you very much, Eric. I am happy to join in the show.
Karibu sana. Now, Mediation Deputy Registrar. Let's just start from there. What is that?
Thank you very much. I serve as a Mediation Deputy Registrar. I am employed in the Kenya Judiciary as a magistrate, but I perform administrative support. In this instance, I serve at the Secretariat known as the Court Annexed Mediation Secretariat, which is a national secretariat that oversees the implementation of the use of court annexed mediation as an alternative dispute resolution mechanism. And the Secretariat coordinates the courts that are where we have rolled out and are implementing mediation.
What is court annexed mediation?
Court annexed mediation is an alternative dispute resolution mechanism. In this instance, anchored in court or under the umbrella of the court. And mediation is an alternative dispute resolution mechanism where parties in dispute are assisted by a neutral third party to reach a negotiated settlement, different from the adversarial resolution where the disputes are heard and resolved by judges or magistrates.
How do you decide what goes towards court annexed mediation?
We have a screening criteria where we look at the cases that have already been filed. The current model that we have enables parties whose cases have already been filed in court to benefit from the process. And we look at a number of issues for those cases where we give a classification that pleadings have closed, which is generally really that all the documentation that needed to be filed by all the parties in dispute are already in place. And most of the cases that we have in our courts are eligible to benefit from court annexed mediation. The only criteria that we sieve through are three cases that we do not refer to mediation. One is cases where we call them the public interest litigation cases. Those ones may not be suitable for referral to mediation unless there's a discretion by a judge or a judicial officer in a conversation that involves all the parties. We also do not refer cases to mediation where there are issues to do with allegations of domestic violence, child abuse, sexual violence, or any cases where we feel like there's an imbalance of power that would generally interfere with the negotiation of the parties in mediation. We do not send such kind of cases to mediation. Cases where there are perpetration of criminal intentions. And then third is we also do not send cases to court annexed mediation where the parties have expressly given an intention that they would like to explore a different alternative dispute resolution mechanism, for example, arbitration.
Okay. So there's a difference between arbitration and court annexed mediation.
Yeah. Yes, there's a difference between arbitration and court annexed mediation. And if you'll allow me to just add in again that the difference that would come in with the adversarial dispute resolution in the court process. In mediation with and arbitration and again in the adversarial resolution in court, all of them, the third parties are neutral and impartial. The difference is that in mediation, the role of the impartial third party is to assist the parties to reach a negotiated settlement. So the mediator does not act as a judge, does not impose the outcomes on the parties, but rather just facilitates the parties to be able to come into a discussion and come up with a negotiated settlement.
Okay.
In arbitration and the court process, the arbitrator and the judicial officer actually determine the outcome and control the process as compared to what happens in mediation. And in the difference, of course, between arbitration and the court process is that in arbitration, the third party is an arbitrator, and in court we have the judges, magistrates, and the cadis.
What happens in mediation if you do not reach this negotiated settlement? That you've gone into mediation, you've been there for however long a period of time, and still folks are not able to agree. What happens then?
We try to really have conversation with our litigants prior to even referring the cases to mediation, to just see that they understand the process and appreciate the benefits that would come with it. And of course, we are very happy to receive cases that are settled successfully so that we don't have to have them again go through the hearing and determination process by the judges and magistrates. But even then, as we give this avenue, which is we are extending to our parties, we do not necessarily tell them that they must go and agree.
Okay.
The replication model we have assumes a mandatory nature only in the terms that once your case is screened and found suitable for referral to mediation, then you are required to submit to the process, to abide by the rules of engagement and the statement of understanding that the parties and the mediator will arrive at, but we do not tell them that they must go and agree. So where they fail to reach settlement, we have these cases back in court. We give directions that facilitate their hearing and determination. And out of experience from the cases that we already have, is that even when parties do not reach a settlement in the mediation process, as at the time they are coming in for the hearing and determination before the judicial officers, it is seamless, it is less protracted, and the cases move faster, and parties sort of have a common approach in terms with how they relate with each other during the dispute resolution.
How do you enforce the outcomes of both mediation and arbitration?
For arbitration, the arbitra's award is forwarded to court, and it is adopted and enforced. Similar for the agreements that are arrived at in under court annexed mediation, they are adopted before the judge or the judicial officer who referred the matter to mediation, and they carry the same weight that they would carry with regard to a decision that would have been made by either a judge or a magistrate. And we proceed to issue the orders and decrees in the same manner, just like the other cases that have been determined, and they are enforceable in a similar manner.
Can they be appealed as well?
Under court annexed mediation, the right to appeal is taken away just purely to be able to avoid the issue of litigation by installments and the delay that would come with it. And of course, we'd really like to ride on the fact that this is a decision where the parties arrived at in a negotiated process. They had the opportunity to participate with any personal representatives of choice. And the reason why that is open is to be able to ensure that sometimes some of the cases that come before us do not necessarily fall within or are not between the disputants in court, and may be stretched out to either people whom the parties are litigating under, or families in succession and family disputes. So to avoid that back and forth process, the mediation process gives the parties an advantage that litigation comes to an end once they sign and execute the settlement agreement.
Honorable Kendago, just give us an example of a case that goes before a judicial officer, and then the judicial officer then sends it to the court annexed mediation. Just a case study.
Thank you. This would be a case which would either be have been filed at the registry and either does not have a date before a judicial officer. In that instance, we look at the pleadings they've closed, and we screen it in a pretrial process where we look to examine whether it falls within the criteria that I had talked about earlier. The second bit in which this matter can again come to mediation is for those cases that are already before the judicial officers and the judges, and in a judicial discretion, they have looked at the file even when pleadings have not closed, and they find that the cases can benefit from mediation. The other third process would be where parties themselves request to be referred to court annexed mediation. We prepare notices notifying parties that their cases have been found suitable and have been referred to mediation. We appoint a mediator from a register that is kept by the Mediation Accreditation Committee, and we communicate to that mediator that they have been appointed to act as mediator. Thereafter, the mediator will contact the parties and advocates in the matter. They will come for a session, which can be either physical or virtual. They will set up their own rules of engagement, which would just facilitate a coordinated process. And then thereafter, they would notify us of the progress in mediation. And we're happy to receive the outcomes, which would either be that they settled or failed to reach settlement.
Without giving specifics of a case, can you take us through one case that has successfully gone through this process, and then you'll tell us the benefits of it?
Thank you. We've had lots of success stories.